Afternoon. This is Ramprasad, Secretary in BCIC. I welcome all of you for today's webinar on BCIC BIMACC Mediation Centre, an effective mechanism for dispute resolutions. We thank Dr. K.V. Omprakash, Chairman, Corporate Economic Affairs and Legal Expert Committee of BCIC, and Advocate and Founder Director, Conscientia Consultancy Private Limited, and Dr. Srikant Parthasarathy, Co-Chairman, Corporate Economic Affairs and Legal Experts Committee of BCIC, and Managing Director, Managing Partner, Chakra Partners. We thank you for sparing time and agreed to deliver the special talk, sir. Thank you. The event is organized under the aegis of Corporate Economic Affairs and Legal Expert Committee of BCIC. We thank our annual sponsors, Brigade Group, Bueller India, Continental Automotive, Fundamax, IMPL, MTR Foods, Ramaya Institute of Management, SDMIMD, Sona College of Technology, TVS Motors, and Vishwas Group of Companies. Now I Dr. Omprakash to take over the session. Over to you, sir.
Good evening all. Welcome to this special talk organized by the committee, Corporate Affairs and Economic Affairs Committee. And we are glad to inform that we are all set to proceed with the BCIC BIMACC Mediation Centre, which was inaugurated and curated during COVID times. Now it has attained its maturity and ready to take compliance for mediation. So this session will be only talking about the alternate dispute resolution, and my colleague and co-chair Mr. Srikant Parthasarathy will be giving insight about the basic difference between arbitration and mediation, which is generally confused a lot of people. So what is mediation? What is arbitration? Who can refer mediation? All these topics will be covered in this 1 hour, and we'll also give a space for the Q&A session. To begin with, BCIC in the year 2021 had partnered with BIMACC. So BIMACC is our knowledge partner, and we signed up an MOU, and the inauguration happened amidst retired judges and N. Venkataraman, additional Solicitor General of India, in October 2021. And already few BCIC members have undergone training, and 6 of us are accredited mediators in-house. So we are already having 6 panelists here. Apart from BIMACC Mediation Centre, we have arbitrators, conciliators, and mediators on them. So a strong team to address all your disputes, any kind of disputes. So this is one of its kind, and I think the chambers, BCIC is the first chamber to have a full-fledged mediation center to address the ADR related issues. BIMACC, being our knowledge partner, has vast experience in resolving disputes, local and international level. They are very strong in online dispute resolution, conducting mediation and arbitration without traveling from respective geographies. So the cross-border mediation and arbitration is happening, and it has resulted and thereby avoided a lot of cost and time. So we would like to extend this support to our members. and outsiders also. We use this facility, the BCIC BIMACC Mediation Centre. Why mediation? Why not arbitration? So most of the agreements, if you see, you will have arbitration clause, a jurisdiction clause. It talks about all the courts in so and so state has jurisdiction. However, an arbitration under the Arbitration Act 1996, the arbitrators will be fixed, appointed one from one side and another from another party. If they are not in consensus, you will have another neutral sole arbitrator or something like that. You will have a huge class there. Most of the agreements, you may not find the mediation clause. Mediation is a very simple method where the mediator does not decide. He only facilitates. It is issue based. When there are transactional issues, the operational teams get into some conflict or issues, which then escalates into a major problem and thereby the relationship is stranded. So mediation helps to address that particular issue and the parties decide themselves and arrive at a settlement. The most important thing is after the mediation, there are likeliness that the relationship also continues. This is the strength of mediation. Whereas in other area or litigation, your relationship gets stranded and you have a third party deciding on your issues. For example, arbitrator who has been appointed, so he has to be appraised. You will have counsels both the sides. So it's a process similar to court. So the basic thing which mediation requires is mutual consent. Both the parties should be okay for a mediation. If they are okay, then the mediation process can be completed within 60 days and you can arrive at a settlement deed. More detailing, Srikant will be telling about what is the legal validity of the settlement deed, stamping, and all those things. So going forward, BCIC will have a small subcommittee which will be in charge of this BCIC BIMACC Mediation Centre and will start sending mails to all the members to incorporate a mediation clause in their agreements. Even members can also approach us, we will help. You can go to the BCIC website. There is a mediation center. Contents have been uploaded. You will find a sample clause there. So you can download that and have it in your agreements. Or if you have problems, please contact us. We'll help you out to frame a clause and put it in your each of the agreement. So that if at all there are payment issues, operational issues, mediation can be a tool for resolving those. Instead of wasting time in sending legal notices, litigation. So this is the motto and aim of this webinar, to create awareness that BCIC has formed a mediation center and members need to use this as a tool. You're open to come, ask questions. We welcome you there. All that you have to do is write a mail or call the chambers. Somebody will help you out. The secretariat is there. You just give them the details. We will send the mails and we will see that your disputes are resolved. Guru, can you run that? So this is what I've been telling all this time, how the center came into existence. The draft rules and mediation center is also in place. We have only fine-tuned. Rates are very, very cheap and competitive. when compared to other mediation centers. We will refine it. Once you send us a mail, the rates will be given to you. Next slide. As I told, you have the contents on the website. And BCIC also has a facility for conducting mediation. However, we will also use BIMACC facility, which is available. It's close by only. So there also we can conduct the dispute. So place is not, venue is not a constraint at all. It's a full-fledged facility is available at BIMACC. Since we have signed an MOU, it should not cost you much. Next. So these are the classes which I was talking about. You have mediation class. Next slide. Arbitration, and sometimes the combination of mediation and arbitration. So these slides, this can be made available to you. You can incorporate those clauses in your agreements. It's not done. A simple amendment has to be done to an agreement, where the other opposite party also agrees to that. So we can help you in that. We have a strong legal team available in this committee. We can help you. All your agreements can carry one of these classes so that you have an avenue to resolve your disputes through ADR, that is the alternate dispute resolution, either through mediation or arbitration or a combination method. So now with this, I would like Mr. Srikant Parthasarathy to detail about the differences between mediation and arbitration and educate members who are here as to how it can be done. Over to you, Srikant.
Thank you very much. Thank you so much for the detailed presentation. I think it is needless to say that mediation is a great avenue for resolving personal disputes as well as commercial disputes, very importantly. So it is very normal and it is very, very common that people think that anything which is not in court is either arbitration, mediation, negotiation, facilitation, everything falls under the same bucket. It is a common misconception. So to take away that misconception is why I have tried to formulate 5 questions or 5 adverbs, which is the what, why, when, how, and the where. Now, the copy of this particular presentation may be made available after redaction. But this is something that I presented to the Judicial Academy and it was very well received. The reason why we need to delve into these 5 questions is the moment we understand the answer to these 5 questions, we are in a position to understand whether arbitration is more facilitative for us or mediation is more facilitative in the light of the current events that are happening in the commercial world. The mediation seems to be the right path, is what you will see. Next slide, please. Now, arbitration, it is very common, like I said, to confuse arbitration and mediation. Arbitration has been the ancient form of dispute resolution. We have had the Indus Water Treaty, which is 1889, 1899. The Arbitration Act, even before 1996, we have had the Arbitration Act of 1889. 1940, even before independence, we had that, which was comprehensively streamlined in 1996 with the Uncitral Model Code. So what we have in India as an Arbitration and Conciliation Act is basically a replica and a derivation of the Uncitral Model Code. Now we have tried something similar with the Mediation Act of 2023 too, in which we have tried to take into account the SIMI, the Singapore International Mediation Centre's code as such. No, the previous one. So while Arbitration Act does away with CPC Evidence Act, one must understand as to the comprehensive updates that have come through in Arbitration and Conciliation Act, which is 2002, 2005, 2015, 19, 20, and then amendments of CPC and the Arbitration Conciliation Act. The reason why we are delving into this particular topic is you may be confused that Arbitration and Conciliation Act has a conciliation element to it. And it is very common to think that arbitration equals to conciliation, conciliation equals to arbitration, which is something that we'll try to address. Next slide, please. Now, this is more of a pictorial representation. You have a fight, you have a legal dispute with a particular vendor, purchaser, client, and whatnot. You are faced with these questions. Shall I go for facilitation? Shall I go for mediation? Shall I go for negotiation? Then there is a deep trench, which is litigation, which you never know where it will lead to, and you never know when it will be successfully completed. Then you have arbitration, negotiation, and so on and so forth. Now, it is a common mistake once again to think that all of these are separate departments, which is facilitation, mediation, negotiation, arbitration are separate. While it is true that arbitration is governed by the Arbitration and Conciliation Act, facilitation, mediation, negotiation, of course, is now governed by the Mediation Act of 2023. A lot of these processes get intertwinkled between the processes which you find in arbitration, and you will understand as to where that leads to. Now, in litigation, you will find that there is a section 89 of the CPC, which says that the court may direct the parties to settle out of the court in the form of arbitration, mediation, conciliation, facilitation, negotiation, and so on and so forth. So the court itself is in a position where the court is recommending the parties that you go to arbitration, you go to mediation, you go to facilitation, in the view that the litigation and the cases in the court should be lessened, and it should be fewer in number. The court itself can suggest. Now, one of the case example which I can give you is when you initiate a commercial dispute with a particular counterparty, and you are sending a legal notice to the other party, and you are taking the party to the court. The court firstly will ask you if you are the party, ask you whether you have tried out other means of dispute settlement. Now, that is coming to the court in good faith. That's the first question that the court will ask you after all your documents are through, and so on and so forth. So the court itself acts as a facilitator in many of these accounts. Now, the reason why we are talking about this is if you have a mediation clause in your agreement, and this particular mediation clause is either available as an addendum to the existing agreement, or available as an amendment to the existing agreement, or even exchange between the parties as email, will prove as a good faith to the court saying that, look, I have a mediation clause with the counterparty. I tried mediation, but the counterparty doesn't seem to be agreeing to the mediation efforts that I've been making. Hence, I've come to the court. So it will only strengthen your case only if you go to the court, if you have a mediation clause as such. The same goes with the arbitration clause too. Now, arbitration clause and the mediation clause, the difference is something that you would have seen in the presentation which Dr. Om was presenting. Arbitration is covered by Arbitration and Conciliation Act. In Arbitration and Conciliation Act, an award has to be made as per Section 31. And the award has to be binding on the parties, and the award can be challenged under 34, 37, and so on and so forth. Now, in mediation, we have a different process. We have a settlement deed. Now, you'll ask me a question as to whether a mediated settlement can be part of an arbitration is something that we'll discuss in some time. Next slide, please. I think the primary question in terms of whether you want mediation or you want arbitration or you want conciliation or facilitation would depend on these largely fair questions, which is wherever it is easier to get going after the dispute. Now, I don't want my commercial relationship with my counterparty to be hampered after my initiation of dispute resolution. I want to continue. For example, you are supplying certain products to the counterparty, and you have an ongoing supply, and you are initiating a dispute with the counterparty. You don't want to have your payments to be pending. So that is wherever it is easier to get going after the dispute. So can the dispute be done and dusted? Wherever it is cheaper to administer. Now, one of the points that Dr. Om was mentioning, it's cheaper to administer mediation in the BCIC. That is one of the primary concerns that you may have. Wherever it would be easier to reach a common ground. See, we may differentiate the dispute into arbitration, into technicalities of arbitration, mediation, conciliation. But at the end of the day, what we would want is we would want a common ground. That is why even the Arbitration and Conciliation Act in Section 30 contains that it is not unforeseen for the Arbitration Conciliation Act to recommend parties to mediation even after the commencement of the arbitration. So an arbitrator himself or herself can recommend the parties to go for our mediation is something that you will see. So at the end of the day, you want the dispute to be handled easier. Wherever you are felt heard, imagine a situation where you are in an arbitration, the arbitrator is not allowing you to speak, your points of view are not being heard. That is one of the primary concerns that you may want to have in having mediation clause imbibed into your agreement. Wherever you are felt being treated fairly, whenever there is a dispute, we want to be treated fairly, let's be honest. So these are largely the questions that you may want to ask yourself before choosing an avenue as to whether arbitration, mediation, conciliation, or negotiation. Of course, there are pitfalls in each of these situations. Next slide, please. This is a dispute resolution matrix, which will highlight on the basis of cost as well as impact. Now, if you see on the top, you've got vertically, you've got high cost, low cost, and then horizontally, you've got high impact and low impact. All of us are trying for cost to be lower, impact to be high. That is our motto of or mantra of business. Now, if you see the cost being high and the impact being high, first is of course litigation. The cost is very high, law firms charge, they are not cheap, as you would know. But the impact is also high. Once a decree by the court is a binding decree, and to appeal on the decree, you need to deposit 50% of the amount and so on and so forth. So its appeal is not that easy. So what you will find in the first quadrant is that the cost is high, impact is also high in litigation. Of course, that's the primary one of the reasons why parties also choose litigation as an avenue, because the impact is quite high and it's a question of the court degree. Then you've got a second situation, which is a lower quadrant, where the cost is high, but the impact is very low, where the companies feel that the impact is very high, but they end up paying high cost, with the impact being very low. For example, delay tactics by company. You have a mediation clause with the counterparty, and you have a situation where you're going to court. Now you would have wasted 60 days, 90 days in the court, only for the court to send you back to mediation and say that, look, you have mediation clause, go back to the mediation center, institute a mediation over there. So these are delay tactics which parties may encounter. Then losing out on pre-litigation time. Imagine a situation where you have a dispute with the counterparty. At that point, you're deciding whether you want to go for mediation, arbitration, conciliation. That is a time-taking decision. And not only from your side, but from the counterparty side too. The counterparty will also be equally reluctant to go for mediation when you don't have a clause in the agreement which says that you have to go to mediation or arbitration. So it is better to have a dispute resolution clause. Instituting alternative dispute in an inappropriate forum. Now, when you institute a mediation or an arbitration with an inappropriate forum, many times, for example, in Perkins, the Supreme Court observed that one party appointing a mediator from their side and saying that you need to bind the dispute to this particular mediation based on this particular mediator. Now that is the counterparty has not signed to it. They have not agreed to this particular mediation. So you have instituted the correct alternative dispute resolution forum, correct alternative dispute resolution mechanism, but in an inappropriate forum. You have not done it properly. That's the reason why institutional arbitration and institutional mediation is something that you may want to take into account. Now, going to the last quadrant before I go to the top right-hand quadrant. Then you have got impact being lower and cost also being lower. These are offhand strategies which are taken by companies. Now they do this to delay the entire process. For example, loose form mediation, saying that I want to appoint a particular mediator, not done appropriately or not done in a proper format, in a proper contract. They say that, look, let's go to a third party, independent third party, who may not be a trained mediator, who may not be the right person to mediate that particular situation. So that is a loose form mediation where the impact is also low and it is also not binding. Then there is no defined outcome, where you go to a mediator without having an understanding as to what you're seeking from the mediation as such. Then you have a situation where you have done this, then you have an outgo of precious pre-litigation time frame. Imagine a situation when you're doing all this and the counterparty has instituted a case against you in the court. You would have only done this in good faith and the counterparty would have approached the court and filed the documents. So you may have a situation where the impact is very low. You may think the impact is quite high, but the impact being very low. Then on the right side, you have got the quadrant, which is cost is lower, but the impact being higher, which is a consultative process. You and the counterparty, even before the dispute arises, you institute in your contract saying that, look, in case of any dispute, let's go to a mediation. Let's go to arbitration. If at all you are not comfortable with mediation, let's do mediation first, then let's go to arbitration. Because arbitration will result in an award, and award will result in finality. Mediation may not necessarily result in finality in the erstwhile regime, even before the Mediation Act of 1923. So then you have a predefined ADR. A predefined ADR is where you know very clearly. Now, Purushot, if you can go to the slide of Dr. O, in which there was a mediation clause. Yes, we can.
So,
Yes, there was.
Wow.
No, slide number 4. Yes. So in the event of any breach of the terms of this agreement, or in the event of any differences or disputes arising between the parties in regard to this agreement or any matter related thereto, the same shall be referred to private mediation under BCIC. So we have got 3 elements. One is breach of terms of this agreement, disputes, differences arising between the parties, and then you have got consolidation, which is any matter which is relating to this particular dispute. Everything shall be administered under BCIC. This is very defined. We know exactly what the dispute is about, what the mediator can do about the dispute, and what would be the award or a settlement deed that would arise from this particular dispute. It's crystal clear. So going back to the slide. So this is what we refer to as a predefined ADR. Then of course you've got ADR financing, which is a different topic altogether. Aligning the goals with the institutional goals. So you've got a situation where, say, 2 members of BCIC are having a dispute. Quite naturally, they're members of BCIC. They would want to get the issue resolved under BCIC. Not only because of the fact that it's a center that they rely on or they have faith on. Also because of the fact that they are members of the same institution. They want to abide with the institutional goals that they may have. Next slide, please. So where do the ADR forms lie in this matrix? You've got high impact, which is litigation. Then you've got on the left hand bottom quadrant, high cost and low impact. You've got a non-standardized arbitration litigation. The frequent complaint which is given by parties is, once I initiate an arbitration, anyway it is going for litigation. Now you make an award under section 34. You make an award in section 31. Under 34, you challenge the award. So you will have a situation where frequently the parties are going to litigation even when there is an arbitration. So that is a pitfall of arbitration. Then you have got lit. You have litigation, go to the court directs you to go to arbitration. Then you go back to the court for litigation. Then on the bottom quadrant on the right side, you've got a lower impact and low cost, which is pre-litigation, loose form mediation. From my experience, from what I've seen, loose form mediation not only results in cost outgo, it also results in time outgo, and it also results in no tangible benefits which are resulting from it. Many a times we would have faced this particular situation where we say, let's appoint an independent third party. There is only talks that happens between the parties, no concrete action. Then you've got a lower cost and high impact. You've got arbitration, mediation, ArbMed and MEDAR process. The beauty of arbitration mediation is arbitration allows for mediation to take place within the arbitration setup. Mediation allows for parties to go to arbitration after the mediation. So there is no barrier whatsoever, except for the barrier that an arbitrator in a particular matter cannot sit as a mediator. And a mediator in a particular matter cannot sit as an arbitrator. As simple as that. For example, I'll give you my personal example. I was appointed as an expert for a particular matter by the courts. The court liked the presentation which was given as an expert evidence. The court appointed in a similar matter for another party as an arbitrator. Now I said that, look, I cannot, even before I took up the appointment as an arbitrator, I cannot take up as an arbitrator because the parties have a mediation clause between them. So it needs a mediator. So the parties applied to the court, they appointed me as a mediator. So it became a situation where our process, mediator was appointed. And of course, the parties have a choice of going to arbitration even after that mediation as such. So if you see the right-hand quadrant that you have, the top right quadrant, this is what we have under BCIC rules. So the ARB-MED, which I was referring to, in section 30, the law is very clear. It says it is not incompatible with an arbitration agreement for an arbitration tribunal to encourage. So it is a myth to say that once you go to arbitration, I cannot go to mediation. I cannot do anything with this particular situation. Let's wait for 18 months for the arbitration to finish. You as a party, you as a facilitator, you can always go up to the arbitration and say that, look, we want to mediate. We are of the view that we are seeing eye to eye. We can agree on a common ground, and we want to encourage a settlement. So the arbitrator can make out an award in the form of a settlement agreement, and that could be delivered under Section 31. Now, the intricacies of that is something which is not relevant right now. But this is something that we have. So it is a common misconception that arbitration, once you go to arbitration, mediation is not available. No, it is available. And it is also a misconception that once you go to mediation, arbitration is not available, which is also a misconception because once you cross the 60-day mark, which is what we have under the BCIC BIMACC rules of mediation, after a 60-day mark, if you still choose to do the arbitration, you can still go to arbitration. But the chances are in the 60-day mark, you would have settled your differences to a large extent. So arbitration is different because it is defined by a court. It is distinguished by process. It is a pseudo judicial process is what you will find because the sending of notice, claim statement, and so on and so forth. In mediation, you need not have all those things. Decided on contract terms. In mediation, you can have a commercial mediation, you can have a non-commercial mediation too. So arbitration, of course, it's a based on contract. Then it is determined by the parties, it is devolved into an award. Whereas in mediation, you've got a settlement deed. Next one. So why is mediation confused in its sense in arbitration? Remember that once you go to mediation, it is a mediation. You cannot initiate a proceeding as an arbitration. While I said you can go to arbitration after the mediation, it is not to be confused as arbitration in between the mediation. For example, when you have a incorrect arbitrator, I was in an arbitration once where the arbitrator himself was facilitating the parties by asking them to make a settlement deed, but also acting as a mediator in between, not fulfilling their role as an arbitrator. So it happens the mediators amongst us will know very well when to act as a mediator and when to act as an arbitrator. The need for understanding of what mediation can deliver as compared to arbitration. We need to be very clear of what mediation can deliver. If you can go back to Omprakash mediation clause. We saw the mediation clause in its first sense as to the process in which it is slide number 4. Now, what will the BCIC mediation give you? The effort shall be made, the last but third line, approved mediator, and an effort shall be made to ensure the disputes are resolved within 60 days from the date of first hearing by the mediator, unless mutually agreed. So you have a defined outcome, which is within 60 days, there will be efforts being made. It's a different question altogether whether in 60 days the issue will be resolved. It may not be, but what is the harm in trying it out is what this particular clause very clearly says. So going back to the
parties, they can extend the period.
Extend the period also, but that doesn't stop you from going to arbitration or going to litigation. Though in all likelihood you may not. Mediation has been codified only by the recent act. It is difficult to say in terms of how far the mediated settlement deeds which are drawn up as per the Mediation Act 2023 are going to remain largely tested by the law. Arbitration and mediation can coexist, but one cannot generally be, we've already dealt with this, one cannot generally be a mediator and an arbitrator of the same dispute. At the same time, unless agreed to by the parties. So parties don't have a problem, that's a different issue altogether. Next slide, please. I'm going to say something that you may not like. For all the promotion which is being done by the government on the mediation and the arbitration front, the government, when it enters into a contract in tenders, it never has an arbitration clause. It never has, let alone a mediation clause. It doesn't even have an arbitration clause. PSUs are the only ones which have, and even the PSU tenders are riddled with problems, primarily because of the fact that they will say that, look, I will appoint an arbitrator, I will appoint a mediator who is going to be my employee, and this employee will decide on the arbitration. Now that is largely being held invalid by the Perkins judgment of 2015, and even upheld by the Delhi High Court as well as Supreme Court as recent as 2020-2023. So any unilateral clauses which says that I will appoint a mediator, I will appoint an arbitrator is going to be invalid. So the point I'm trying to make over here is all these PSU contracts are now going to be amended. There is a large avenue for BCIC to pitch into these PSU contracts and say that can they have BCIC as a, because at the moment the PSUs don't have their own center. They can only refer to BMC. Now BMC, you have a case log of 4 months, even before the case is initiated. So why would they want to go? For example, a commercial dispute, they may want to come over here. I don't know if PSUs are members of BCIC or we don't have, at least we have got members who are working with PSUs in our chamber at least. And so that is something that we may want to work with. Of course, PSU have their own dispute resolution mechanism as per the 2020 notification, but nothing stops us from approaching these companies who are working with PSUs to have their contract to be amended. Then it is important to incorporate an ADR clause. You will be surprised that 90 and 95% of the contracts don't have an ADR clause. They will have a governing law. They will say that any dispute will be governed by the law of Bangalore or the law of India, and the courts of Bangalore will have the jurisdiction. Now, not to name a company, but a popular food delivery company has the same ADR clause. It says arbitration, but it has jurisdiction of the courts. Now that is a flawed clause as such. So it is important to educate our members that they can approach their counterparties in whatever contract they have to get it amended, and any reference to they need not have an amendment in the contract. All they need is an addendum which can be added to the contract. It says that in case of a dispute, it's just 2 lines that we need to add. That is something that we need to educate. Depending on what they want. If they want arbitration, they can choose arbitration. If they want mediation, they can choose mediation. If they want mediation and arbitration, they can choose that. Next. So when to agree? This was the last question that we had. The what, where, how, when. So when to agree on invoking the arbitration? Technically, it could be invoked at any point before or after the appointment of an arbitration. Mediation in an arbitration, you could invoke it at any point. You need not even worry that you have appointed an arbitrator and think that no, I cannot go to the mediator now. No, you can invoke at any point. That is what section 36. If invoked after the appointment of an arbitrator, there must be an agreement. And the arbitrator cannot challenge. If 2 parties are coming together and saying that, look, we want to go for mediation, we don't want arbitration, the arbitrator cannot challenge that. In my experience, I have advised parties where appointment continuing work between parties. The escalation cost of arbitration, escalating cost of. See, in arbitration, the problem is even after arbitration, they may want to go to litigation. Whereas in mediation, at least you have settled the difference. You're seeing eye to eye. To a large extent, you may want to see eye to eye. You may want to settle out your differences. Of course, there could be hybrid situation too. You may want some of the disputes to go to mediation, some of the disputes to go to arbitration. For example, complex contractual claims can go to arbitration. Simple matters, for example, you have supplied 10 bulbs, I need 11 bulbs. These simple matters could go to mediation. That is also permissible by the law. So this is something that members need to be educated about the different avenues which are available. So both of them can coexist. Next, please. How to agree on mediation? Simple. by referencing the mediation clause of the institution in the contract. Very simple. I need not even imbibe the BCIC clause. I can merely say, in case of any dispute between the parties, the BCIC BIMACC rules on mediation shall stand. That reference is also a reference as per the law. So the parties need not even amend by putting in the entire clause. They can even amend by saying this. By agreeing on mediation after the dispute, so you have initiated a dispute. After the dispute, you come and say that, look, BCIC seems to be a good place. Let's initiate a mediation and arbitration over there. By giving reference in the claim statement, or by oral reference to the arbitrator, or the easiest and the most paradoxical way, you could speak to the counterparty and say that, look, arbitration is costing me too much. Let's go to mediation and let's agree. Because in institutional mediation and institutional arbitration, there are fixed rates. You generally cannot go beyond a certain rate in an institutional arbitration or institutional mediation. So you know very well as to how much you're going to spend. Unlike litigation where you are spending per appearance, per IA and so on and so forth. Next one. Now the question is where? Where do we institute the mediation? Hopefully it will take place in the BCIC Mediation Centre. Any other place with BCIC rules. Any other place with any other mediator by taking the principles of the BCIC. So of course that is not a preferred way, but our rules permit BCIC rules being applied and mediation taking place elsewhere too. BIMACC. So it's largely flexible. So these are the points that I wanted to highlight. Thank you so much for your time.
Thanks, Srikant, for your elaborate insight on arbitration, mediation through arbitration. Any point of time, people can resort to mediation. Thought. Coming back now, what is the process? Let us discuss about what exactly, how the mediation process happens. I have here across Mr. Murli is there, he's a mediator, GGS is there, he's also I'm not a mediator. We have all undergone a training and the accredited mediator. So basically a complaint has to be filed. And the registry take the complaint and send the notice to the party. And a mediator is appointed from the panel. So of course, a mutual consent has to be there between the parties. The fees, structures, all those things need to be accepted, and upon payment of the fee, the mediation process begins. The appointed mediator introduces himself to the parties, and that is a choice meeting between parties who are present there. And once the mediator introduces himself, he starts with a joint session to understand here from both the parties. That meeting is going to be very informal or kind of introductory session. Then the mediator gets into private session with each parties to the dispute, understand the issue or the real problem in the transaction which led to the dispute by having private session with both the parties, can be even three parties also. So once the mediator is aware about each party's dispute, tries to refine and again has a joint session, allows the parties to understand more about the dispute, talk about the dispute, and he facilitates. Again, I'm telling you, a mediator does not decide. He's not a decision-making authority at all. He's not a conciliator. He's not an arbitrator. He just allows the parties to address their issues, goes threadbare in the issues which doesn't happen in litigation. In a litigation, there are thousands of cases pending on the judge. You get only 2 minutes time to present your problem And it all depends upon your advocate, his mood, judge's mood, and other conditions and circumstances, what happens to your case. But here it is not so. It is a private, only the parties to the dispute are there. They can address their issues more elaborately, bring more documents, substantiate. The mediator helps make the other party also understand why this dispute has happened. Whether the operational team understanding was not there, or there was not a consensus ad item was not there. All these things can be dealt very deeply in a mediation. Paperwork is very little. Again, I'm trying to say this. The parties decide here. They resolve the issue. Mediator allows them to draft a settlement deed. He only helps. He puts legal terms here and there, but the settlement is done by the parties. Thereby, the relationship can also again continue in a mediation process. This is the strength of mediation. Whereas in litigation, we don't know how long it will take and whether the dispute will be resolved, we don't know. There will be a lot of interlocutory applications, IAS pending, and things will go on. The advocates have a lot of role to play there. Here, the parties have roles to play there. They can advocate themselves for their issues. They can also engage a lawyer to put it across properly. So this is the strength. And once the parties arrive at a settlement, it is drafted, a settlement deed is drafted, signed off, and then the institution stamps, under its stamps, gives the settlement deed. Both the parties can hold it. Of course, because of the litigation, the court order has its own strength. But here, this is mutual. And I feel since a lot of efforts are gone in, this is also strong. We can appeal. Now that they cannot appeal. But the bottom line is, since the parties are settling the matter, it is going to be forever. The relationship will continue. So with these few words, I think we have given enough insight about mediation and architecture. I would like, if anybody has any questions,
if I can start, Mr. Omprakash and Mr. Srikant.
Yeah.
First of all, thank you for the wonderful presentation. Very good insights and an introduction given to the role of BIMACC. My experience of late has been that in a lot of these PSU contracts, we still see the clauses of ad hoc arbitrations. And whilst institutional arbitration has been getting advocated in India and, larger matters get referred to the Singapore courts or to the London courts, we still find, the same clauses of ad hoc arbitration being repeated in most of these contracts, over the years. Now, with the mediation bill having been passed last year, one, uh, is there also a role play at the larger level, center level, etc., that the PSUs come up to speed? And, one is that they advocate institutional arbitration. And second, also have a clause of mediation, which we will enable the counterparties. And largely, my experience has been that most of these contractual disputes that I see arising, have involved, government or PSU counterparties significantly, be it the NHAI, PGCIL, NTPC, etc. So that was my first question. And second, within, BCIC, if other members would like to get trained as mediators and, is there a policy in place so that someone like me who's interested could, participate in the process?
The first part, I think Srikant, you can answer. The training part, I can answer.
So, Pankaj, PSU to PSU disputes are going on a mediate. If you see the 2020 Law Secretary Office Order, PSU and PSU disputes are between PSU, NHI to NTPC disputes are largely following the mediation mechanism. It's not going to arbitration, if you see.
Okay.
2020. So there was an office order which came through which says that if at all there is a dispute, the party should try to resolve by bringing it to attention of the law secretary. And then it is a mediation which will happen between, or an attempt to mediation which will happen. Now, what you will find in some of the PSC contracts is a little bit of an over enthusiasm, right? Which is they are trying to bring in arbitration. Then there's a clause which is there in the tender itself, which negates the arbitration clause, which is there in, say, point number 14.2, a 13.1, which will be, for example, 13.1 may concern, we may have a clause which says that in case of any dispute between the parties, the PSU will appoint a neutral third party who shall endeavor to resolve the disputes between the parties. Then they will say that in case of any dispute, again in 14.2, which will say that if the dispute remains unresolved, then the parties may approach an arbitration. These are conflicting clauses. So what you will find is an ARB-MED, which is not very defined, which will say in case of any dispute arising between the parties shall attempt to resolve amicably. Now, how will you define resolve amicably? I can keep it on pending for 3-4 years, trying to resolve amicably, even before I could go to court or even before I could go to mediation. So I think from a PSU point of view, the existing contracts anyway have to be, they have to be changed with the unilateral appointment being
Correct.
held
That
invalid.
is, yeah. That
Has been,
it is
so
valid.
I think we need to at least educate amongst our members in BCIC not to have a replica of those clauses. Which are, you may see what happens is a legal person takes a clause from a PSU, which is an open tender which is available, puts it in their agreement and thinks that is a perfect clause.
No, Srikant, I think you brought out a very valid point, at least for a lot of the SME members of BCIC. The unilateral appointment of our arbitrator by the, awarding by the counterparty from their panel. This is something that a lot of members don't even and may not even be aware that this is, since the courts have ruled against it, and and a lot of these contracting firms, SMEs get into trouble largely because of these unsettled claims. And when there are unilateral appointments, there's a high probability of bias also coming in there.
Right.
Yeah, regarding your second point, which you asked about the training, yes, definitely with BIMACC in place, since we have an MOU, we'll come up with a training session where a week's training is given for a member to become an accredited mediator. So it's a week session. It can be either online or in a physical format also. So it's a full 1 week pair, and you will be trained of various methodologies and theories, practical sessions, and you will be accredited as a mediator. So that we will come out shortly. In fact, in association with some law colleges also we have been trying, for example, KLE and other Christ College. So we can associate so that you will have a recognition with a college emblem. So
But
that can be.
But we may want to have the mediators who are trained to be of the MCPC level. No? So you should be eligible for say a court appointing you. Not only when you get trained under BIMACC, you should also be the court should also know that you've been trained under BIMACC. You follow the MCPC guidelines, and you are eligible to be appointed as a mediator for court-related appointments too. If that is I mean, that is something that members would want.
Yeah.
Yeah, I see a lot of interest, in fact, institute members, company secretaries and chartered accountants, they are also likely to join this session. We will put across this. So if a batch of 20 or 25, if we can team up, then definitely it's in place.
Sure.
What
Another
happens is,
thing, sure,
what
sure,
happens
no,
is,
no.
it's a 1 week session, people may tend to, they will prefer, why don't we have it in a weekend, all those things. So that's why this is not happening. People have to.
Otherwise, we can have it on 2 consecutive weekends also, Mr. Omprakash. Saturday, Sunday, or Friday to Sunday. But we should have this because it will benefit a lot of, our CA and CS members. And also, they in turn could educate a lot of the SME, MSME members on this. So
Definitely, we will figure out this. Your point is well
Mr.
taken.
Omprakash, we were also looking at conducting the 2-day seminar, which would have again helped a lot of our members. Now, significant arbitration matters also involve the participation of experts. You could have a technical expert, you could have a quantum expert who testify in the tribunals and who are crossed, etc. Now, in mediation matters, especially some of these could also involve, technical matters where the mediator may not be very well conversant. Now, is there also a provision that the mediator could request for an independent expert to come and give his opinion?
It depends upon the dispute on hand. Definitely, if there is a expert opinion required on a dispute, definitely we can call for expert opinion, right? The mediator is not aware about that.
I mean, we'll have to look at parties who may not want to, have a third party. I'm aware of this.
Parties should consult.
No, I'm aware only of arbitration. About mediation, I'm not aware. The parties, see, there is a common misconception, right? I mean, you go to a mediator thinking the mediator is expert. So parties may say that, look, why should I bring in an expert apart from the mediator? At least in arbitration, you know that the arbitrator is the next judge and whatnot. In mediation, generally, there is a misconception. So I don't know. We may have to, the general rule is the parties, if they consent, if they want a particular expert to testify, they can.
No,
But
I
in
mean,
fact,
I was also referring exactly there, Srikant, that even during arbitration proceedings, whilst the arbitrator himself is not an expert, and depending on the severity of the matter, you may have experts on either side, or you have a common bench of experts that both parties may wish to rely on. So, yeah, I think you answered it well. Thanks.
Right, thanks, Pankaj, for the question. Any other questions? Okay, we conclude the session. Thanks all of you for participating this session. And before closing, I would again request BCIC has a mediation center wherein BIMACC is a knowledge partner and association with BIMACC. BCIC has established a mediation center and request to all the members to first see that whether their agreements have a mediation clause. If not, please contact us. We will help you in redrafting or bringing an amendment to the agreement so that in case there are disputes coming up, BCIC can help you in addressing the disputes. And with this ending note, I will conclude this meeting. Thanks to everybody for attending this. Thank you.
Thank you.
Thank you.
Thank you.
Thank you so much, Mr. Srikant and Mr. Omprakash.
Thank you.